Preventive imprisonment. Preventive imprisonment. Not all persons who have pending trials of criminal cases must be detained. Since accused person has the constitutional and statutory rights to bail, so persons who may be committed to jail pending trials are those charged with capital offenses with non-capital offense who have failed to post bail, and those charged with capital offense and the evidence of guilt is strong. So, preventive imprisonment is imposed upon a person before he or she is convicted if he or she cannot afford bail or if his or her criminal case is non-bailable. Period of preventive imprisonment deducted from Term of Imprisonment Republic Act Number 10592. Offenders or accused who have undergone preventive imprisonment shall be credited in the service of their sentence, consisting of deprivation of liberty, with a full time during which they have undergone preventive imprisonment, if the detention prisoner agrees voluntarily in writing after being informed of the effect thereof and with the assistance of counsel to abide by the same disciplinary rules imposed upon convicted prisoners.
Persons not qualified under the law. When they are a recidivist or have been convicted previously twice or more times of any crime, it means that when they have been found guilty of a murder repeat or multiple times. B. When upon being summoned for the execution of their sentence, they have failed to surrender voluntarily. It means that if they have refused to stand down deliberately when sent for the implementations of their statement. Credits in case the detained does not agree. If the detention prisoner does not agree to abide by the same disciplinary rules imposed upon convicted prisoner, he shall do so in writing with the assistance of a counsel, and shall be credited in the service of his sentence with 4 2/5 of the time during which he has undergone preventive imprisonment. So, it means that if a detained inmate doesn't really agree to abide the very same administrative norms as guilty inmates, he must do so in writing with a legal representation and will given credit for 4 2/5 of a time spent in a preventative custody when serving in this or his time. So the notes. Credit for preventative imprisonment for the penalty of reclusion perpetua shall be deducted from 30 years. Whenever an accused has undergone preventive imprisonment for a period equal to the possible maximum imprisonment of the offense charged to which he may be sentenced, and his case is not yet terminated, he shall be released immediately without prejudice to the continuation of the trial thereof, the proceeding on appeal, if the same is under review. Lastly, computation of preventative imprisonment for purposes of immediate release under this is immediately preceding paragraph shall be the actual period of detention with good conduct time allowance. In this case, the maximum penalty to which the accused may be sentenced is desterro. He shall be released after 30 days of preventive imprisonment.
Good conduct time allowance. Reduce in the actual time an inmate prisoner serves his/her sentence, usually because he has complied with jail presence rules and regulation. Good time have frequently been classified in our different ways. Presence overcrowded include word release and pre-release. So good conduct time allowance allows for a reduction of sentence of person deprived of liberty depending on how will they obeyed by the rules and regulation inside any penal institution, rehabilitation or detention center, any other local jail.
Special time allowance for loyalty. A deduction of 2/5 of the period of his sentence shall be granted in case said prisoner choose to stay in the place of his confinement notwithstanding the existence of a calamity enumerated in Article 158 of this Code. The purpose of the law in granting a deduction of 1/5 of the period of sentence is to reward the convict's manifest intent of paying his debts to the society by returning to prison after the passing away of the calamity. Authority to grant good conduct allowance. Whenever lawfully justified, the Director of the Bureau of Correction, the Chief of the Bureau of Jail Management and Penology, or the Warden of Provincial, District, Municipal, or City Jail shall grant allowances for good conduct. Such allowances, once granted, shall not be revoked. Note that RA 10592 provides for punishment in case of non-compliance or violations. Section 6 Penal Clause, faithful compliance with the provision of this Act is hereby mandated. As such, the penalty of 1 year imprisonment, a fine of 100,000 pesos, and perpetual disqualification to hold office shall be imposed against any public officer or employee who violates the provision of this Act.
Delay in the delivery of detained person to the proper judicial authorities. Article 125 RPC, a felony committed by a public officer or employee who shall detain any person from legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for crimes or offenses punishable by light penalties, 18 hours for crimes or offenses punishable by correctional penalties, 36 hours for crimes or offenses punishable by afflictive or capital penalties. The crime of arbitrary detention is committed when the detention of a person is without legal ground. The legal ground of detentions are A. Commission of a crime, and B. Violent insanity or other alienment requiring compulsory requirements. Delaying release, this is committed by a public officer or employee who delays for the period of time specified in Article 125 the performance of any judicial or executive order for the release of a prisoner or invalid delays the service of the notice of such order to said prisoner.
Infidelity of public officers. Number 1. Infidelity in the custody of prisoners through connivance. Article 223 RPC. A felony committed by any officer who shall consent to escape of a prisoner in his custody or charge shall be punished. Letter A. By prison correctional in its medium and maximum periods and temporary special disqualification, in its maximum period to perpetual special disqualification, if the fugitive shall have been sentenced by final judgment to any penalty. Letter B. By prison correctional in its maximum period and temporary special disqualification, in case the fugitive shall not have been finally convicted but only held as a detention prisoner for any crime or violation of law or municipal ordinance. Number 2. Infidelity in the custody of prisoner through negligence. Article 224 RPC. A felony committed by a public officer when the prisoner under his custody or charge escaped through negligence on his part. Number 3. Escape of a prisoner under custody of person not a public officer. Article 225 RPC. Any private person to whom the conveyance or custody or a prisoner or person under arrest shall have been confided, who shall commit any of the offenses mentioned in the two preceding articles, shall suffer the penalty next lower degree in than that prescribed for the public officer. Other offenses or irregularities by public officers. Number 1. Maltreatments of prisoner. Article 235 RPC elements. Letter A. Offender is a public officer or employee. Letter B. He overdoes himself in the correction or handling of such prisoner by imposition of punishment not authorized by regulation or by inflicting such punishment in a cruel and humiliating manner. The felony of physical injuries, if committed, if he accused does not have the charge of a detained prisoner and he maltreats him, and if his purpose is to extort a confession, grave coercion will be committed.